Thank you for joining this episode of our webinar series on best practices in eDiscovery. Today's session is focused on mastering privilege protection in document-intensive matters. My name is Jeff Fugit. I'm Chief Revenue Officer for Lexbe, and I'll be the moderator for today's event. I'm going to talk to you a little bit about our webinars. Our webinars take place monthly and cover a variety of relevant eDiscovery topics, trends, best practices, and strategies. Space is limited to the capacity of our webinar platform, and with the popularity of these sessions, I recommend registering promptly for the sessions that are of interest to you. If you have technical issues or questions, please email webinars@lexbe.com and we'll address them right away. Our webinars are available online at lexbe.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexbe.com. To be notified of future live and on-demand events, please email us at webinars@lexbe.com or follow us on LinkedIn. Now a little bit about Lexbe. We're based in Austin, Texas, and we provide a very affordable, high-performance, cloud-based eDiscovery solution and services. We specialize in equipping the boutique firm with an eDiscovery solution that gives them full control over the eDiscovery process, DIY capabilities, and very fast performance. We're the industry's most affordable and full-featured DIY eDiscovery platform. We're the industry's fastest eDiscovery processing and document review platform. We deliver the industry's fastest return on investment per a study that was done by G2 Crowd. We have highly experienced eDiscovery specialists and expert consultants who are all ACED certified. And if you'd like a demonstration of our platform, simply email us at sales@lexbe.com and we'll get that scheduled for you. Joining us today is Gene Albert. Gene is the CEO of Lexbe. He is a frequent speaker and author on eDiscovery and legal tech topics. He is on the Planning Committee, Electronic Discovery Institute at the State Bar of Texas, and he is an eDiscovery consultant and expert. Gene has a BA and MBA from the University of Texas and a JD from SMU. So this topic is fascinating, especially given the shifting ESI landscape and the proliferation of communication channels, as you can see on this slide, from Slack, mobile messaging apps, as well as the growth in the number of email accounts per custodian. All of this exponentially increases the challenge of identifying and protecting privileged documents. Skype in particular has been a source of privilege disclosure in some very high-profile matters. In addition, if you utilize an intelligent virtual assistant, if you have any of those devices enabled in your environment, like Amazon Alexa, Apple Siri, or Google Assistant, then you'll want to make sure you've got your bases covered when it comes to protecting privileged communications. Luckily today we've got Gene who will walk you through the best practices and critical steps to ensure you're protecting privileged documents. Before I turn it over to Gene, I wanted to ask for your participation in some polling questions to help set the stage for today's presentation. And our first polling question is, what percentage of your matters do you consider document intensive? And while you're answering that, I'll take this time to thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And our next polling question is, have you ever had to utilize a clawback agreement due to inadvertent disclosure? All right, I'll go ahead and close that poll. And without further ado, I'll turn it over to Gene Albert. Gene?
Hi, I'm Gene Albert, CEO of Lexbe. Thanks for joining us today for the webinar Mastering Privilege Protection in Document-Intensive Cases. A couple of comments I want to make before we get started. First, I can talk pretty fast. We've got a lot of material to cover, so I apologize for that. And streaming video and PDF of the deck will be available shortly after the webinar for anybody who wants it. Second, I use our own software, the Lexbe eDiscovery platform, as illustrative examples, of course, for functionality, but the similar functionality in large part is going to be available in other modern eDiscovery software programs. So what I talk about is of general usage. Third is a short survey afterwards, and please stay around and complete it if you can. We review these very closely to improve quality of our educational webinars and how I and others do these. So we'd love to hear what you have to think about what we've done, and you can also suggest other subjects you'd like to see as well. For the agenda today, we're going to go over causes of inadvertent waiver, the legal requirements under the federal rules, optimized workflow and logging, and some particular issues that come up, email threading, near dupe analysis, categorical logging. Then we'll finish up with the tips and best practices. This next slide just shows the amount of data growth and what that means and the impact it has on privilege claims. The data that's in a modern case just continues to grow as we use more and more communication methods, and it's amount of just the sheer mass of it, but also the different types that are coming online. So we're seeing more and more text messages and corporate IMs, social media being relevant in cases, so that needs to be looked at as well, and gotten into a form that can be readily searched and coded. And obviously the data is going up, but the case budgets and timelines aren't. So there needs to be better and better technology to be able to do this properly. What are the risk, problems, and privilege review? Well, first off, there's just more to review than there used to be. And then secondly, we use in modern cases, it's not practicable to have somebody put eyes on every document. So you have to rely on technology to review, usually search or possibly TAR, to identify documents that are potentially privileged. Third, often there could be reviewers that aren't familiar with the case, so that can be complications on making sure that for coding in general and possibly privilege and work product in particular. Also, there's many exact duplicates, but also near duplicates documents that don't quite get are not close enough that they can be caught up with a common hashing algorithm to be identified as an exact dupe. So those need to be identified, and that can be a particular problem with privilege control. And another issue is handling related emails, threading, or just closely related emails. How is that done with the view to making sure that privileged documents aren't missed? Go over the rules having to do with this, and the ABA model rules, of which most states rely on, are not very detailed. There's a 1.6 says you shouldn't reveal information without consent, representation, and then the A, and then C is that the lawyer should take reasonable precautions to prevent unauthorized or inadvertent disclosure. Then under the professional conduct rules, 101 requires competent representation, and also that the lawyer keep abreast of the law, including the benefits and risk of relevant technology. Some states go further. In particular, Florida has requirements for COE on eDiscovery and other litigation technology. I'm not aware of any other states that have required that yet. The Sedona Conference, which is a thought leader of mostly judges in this area, says that litigants should use appropriate search and retrieval methods to leverage processes and technology to include quality and efficiency. So mom and apple stuff there. The federal requirements on the rules are the federal rule of evidence says that an inadvertent waiver will not lead to a broad subject matter waiver, and 502D enables parties to establish a discovery protocol, and also particularly refers to clawback agreements in the there, and then the comments And also, this allows for categorical logging, which we'll talk about later. These can, under 502D, this can be part of the party's agreement and an ESI order or other court scheduling documentations, or the court can also do this on its own initiative. The Federal Rules of Civil Procedure under 26, where it's addressed, interestingly, we don't talk about privilege log requirements in much detail. This has been left to case law or local rules, I'd say, given the importance in cases. So this gives a very general description of what needs to be in a log. But in case law, the courts have required more specific logging. Here's an SEC case that I think generally addresses the state of the law now, which is general nature of the document, the author, date written, information about the addressee, anybody who received copies, the document's location, and the reason it's been withheld. The case law really hasn't been updated, as far as I've seen, very much to specifically get into some of the issues that are involved with modern email and other modern communication systems as to what information is reasonably available as part of that. One that I found that's interesting was a recent 2019 case where the judge in some BlackBerry litigation approved a litigation privilege log on review. This wasn't a requirement that this would be in all cases, but just one that came before the judge that the judge approved. But it gives you an idea of some of the stuff that can be included in privilege logs, although I think this goes beyond what I've seen in other cases as being a requirement. But this one had a document control number, which is probably a base number, a document class, or the type of document. If it's in an email chain, the date of the parent email, if it's part of a chain, the author, recipient, individuals copied or BCC'd, indication if anyone who authored, sent, or received it was an attorney, the general subject, and a general description of the document, the privilege asserted. That's a very comprehensive list, and I don't see that generally being done, all those in all cases, but this sort of information is generally available in our and other eDiscovery platforms, so this can be included in a privilege log if that's what is needed in the case. The law on privilege logs is use it or lose it. That if the danger of an improper log or not supplying a log at all will be that this could result in waiver. There's arguments against that in the article I show, and courts are, of course, disinclined to do that very quickly, but that's always a risk if the privilege logging rules aren't followed adequately. There's special issues that come up with privilege and privilege log, corporate communications, who's the client. There's different rules in different states and different jurisdictions. If in-house counsel is giving legal or business advice, that comes up a lot in litigation. There's a joint defense common interest privilege that's used in joint litigation, lots of rules around that. There's also a fraud exception that shows where that was litigated, again, in a recent case in 2019. An issue that comes up is how to handle emails and attachments. As part of ours and other modern eDiscovery platforms, the attachments will be separated from the email body and separately processed, and then they'll be associated back in for review. They're actually carried as separate documents. And the question is, what do you do if an email body is privileged and the attachment isn't, or vice versa? There's several different ways of handling this. It is possible to break the email families and separate the association from the email body from the attachment in our system, and some other systems do allow that. But in my experience, that's usually not the best, because that can cause review and production questions and platforms, because the email body will show that they're attachments and then they don't all get produced, and then questions arise about that. And not that can't be handled, or that's not the appropriate thing to do in a particular case, or if that's the preference of the attorneys in the case, but it's not without its problems. It's no panacea. Sometimes if the attachments have been produced separately and somebody does a review and is comfortable with that, they're can be comfortable with withholding duplicates and a privilege log, even though they're technically not, I'm referring to attachments here, they're technically not privileged if they've otherwise been produced just in the name of efficiency of review. And that can be a good solution, and if that's acceptable to the parties, and judges may think that's just fine, even if one of the parties doesn't accept that. But that can be an issue to address. A good solution mostly is to take is to produce or withhold the email families as a group. But if an email, but that it may be possible in many emails to go in there and create a redacted version of whatever was privileged in the email body or the attachments, and then go ahead and produce it as non-privileged at that point, and then create a separate log that's redacted privilege information, and log that in a similar fashion as one would a privilege log, and then just go ahead and release it. And that's usually satisfactory if it's not too burdensome to do the redaction, and that makes sense when the privileged portions of the email family is minor compared to the the overall amount of the email family. All of this may be addressed specifically in an ESI order or otherwise agreeing on this, but these are some of the issues that can come up. Another issue is how to handle email strings, and here I'm referring to not separate emails that could be part of one overall conversation, but instead when somebody does reply or forward where you can get often a very long string of different emails and forwarded emails, but they're all within one document. Theoretically, those could all be chopped up and made into separate documents, but nobody ever does that, since that would just be incredibly expensive and a very manual process to do that. So again, there's a question of how to deal with that. There's some different rules on that, or different approaches courts have taken on that to log it. But one way to do that is to look at the overall conversation, and when logging these email strings, to have all the senders and all the receivers in the to and from, and then the date range handled for these, and that can be a way of handling that. Sometimes what's logged is just the uppermost email, or the last one, and that's commonly done because that's the information that comes out of the system without some manual coding that goes in there. Another possibility is to go in there and again redact out whatever's privileged, and then go ahead and produce the redacted version of it, as I just mentioned. Search is very important, and the main way people find privilege logging. It is possible to use predictive coding for privilege logging, but it's not very specific, and I'm not sure that the law is really there that allows that without agreement, that you could be withholding privileged information based on the based on what a predictive coding algorithm or TAR algorithm would find. So there may be something out there. I've never seen it, and I'm not sure what the basis for that would be. So normally either manual review or search is what's used to find privileged information. So that's very important, the quality of the search and the methodology that's used. Sedona Conference again talks about that and says that there should be, you should be able to substantiate the methodology. There should be quality control measures, and it should be tested and verified through sampling or other techniques. Here's an example of how that works in our system. You can use simpler Boolean searches, and there's different ways of doing it. There's certainly having a Google type search that's very simple to use. It has got a lot going for that. It's not overly complicating things. A lot of other search options. There can be, you can add in concept search, or do fuzzy or stemming, which will give approximate versions of it, and take it back to a root word for the searching with the stemming. Boolean, you can do complex Boolean, and then it'll show keyword highlighting, off of the search when you open up the document. We do a couple things that not everybody does. We have something called an Uber index that I'll talk about a little bit later that shows that adds in the native text extraction along with the paginated or imaged or OCR versions of it that can give a broader search results. Also, you can integrate in translations that have been done into the record as well from a foreign language into English. This is again this shows the document viewer in our system, and here you've got different versions of the documents under different tabs. So you can look at the extracted text or the OCR version or the redacted version, etc. So that can be helpful in doing one's privilege review. This shows the privilege workflow where you can go in there and do search result and then do an auto update. Updating the number of documents here, 421 to responsive. That could have been privileged as well. Any of the built-in or custom fields can be auto updated like that, and be the same in other modern systems as well. Another thing that's helpful in doing privilege review is that when one's going through documents, looking at it, the propagate coding field on the upper left codes the entire email family at one time, which usually is what people want to do, and then that can be done on a one at a time or on a mass basis off of search results to speed review. The Uber index I referred to was something that we have, is that most search engines will either index native extracted text. This would be things that parsers can pull out of Word or some Excels or similar documents, and that goes into a search index. Or they'll be imaging the documents first into a TIFF or very common, or sometimes other image file formats, JPG, PNG, and then running OCR on that, and then doing the search off of that. Some systems will do both and have them in different indexes, so you have to go and do a separate search each time. What we do is we join those together in one index, so the search always gets both of those. I think it is a good idea to have a system where you can search to both, because they'll bring back surprisingly different results. The native extraction will pick up a lot of things that an index, or I'm sorry, an image version will not, such as text that's hidden sheets, print selections, comments in PowerPoint or Word documents, number of things are missed. But then the native extraction will also miss anything that would benefit from OCR. So any faxes, attachments that come in as images, embedded images inside of Word documents, Excels, or PowerPoints, all that wouldn't be searchable in a system that merely does text extraction and does get picked up with the imaged OCR. So for us, the best answer is to bring in both, and this is important when one's doing a document review, to make sure the search brings back the maximum number of documents that you think it is possible with the technology, but is even more important with privilege review. Another issue is how to handle email threading, and this is taking associated emails out of an email chain and allowing a visual representation of them together and coding together. We've recently released a visualization tool that you can see here where it shows the thread, which is built up based on metadata in the email to associate it with other emails that are in the document collection. So you can click on one through the other and see how they're associated and get the details of them, and then show how they went from one to the other. And then you can also jump into the individual email and go from one to the other in the document viewer as well. That interesting also shows that there were some missing emails here that didn't get collected for whatever reason, and that'll come up sometimes where the metadata in the last email will refer to earlier emails that you might have in the collection, but not middle ones, and that can be sometimes interesting to see why that was missed, and if that was what was a reason for a holes in a production. And we cover that in another webinar in more detail. Another great technology for email review, and privilege review is duplicate detection. Exact dupes are identified in the system based on metadata off of emails and having exactly the same, or substantially the same metadata, and also a hashing algorithm on native documents that allows you to identify the exactly the same document that's been produced multiple times, including attachments. But those will not be all versions of documents that appear to be identical or are very similar. So an example of it is if you had a Word document in a collection and also a PDF version of that same Word document, though they're exactly the same documents by all appearances, they're very different to the computer and they would not come back on the same hashing algorithm. Also, there's a lot of certainly versions of documents that have minor differences between them, both emails, but also versions of documents like a merger agreement or something where there's many different versions of them, and some are slightly different. A near dupe algorithm will bring those back together in one near dupe grouping. Another example would be a document is produced and then another version of it's produced that has handwriting on it that would not hash the same, but once OCR was done and the near dupe grouping algorithm was applied, then those would come back as near dupe groups. So this gives an example of how a near dupe group comes back, where you can see similar emails here that even though they're separate emails, there's enough similarity in text, which is usually 50% of the text in general or greater puts it into a near dupe group. But the algorithm's more complex than that. But that's generally what happens with that. It allows you to look at them all at the same time, review them, and possibly code them all at the same time. This is particularly important having to do with privilege. What we'll see sometimes in the case law is that sometimes reviewers have caught sometimes many versions of privileged documents, but some have slipped through the cracks because of differences in reviewers, or somebody just missed it. And it's kind of a shame that somebody was able to identify a privileged document in one case, but then wasn't able to, the system didn't pick them all up. And that happens more than one might think, because it's just a matter of individuals looking at it, and individuals make mistakes. The near dupe grouping technology can be really helpful here, because you can go through your near dupe groups after you've done your privilege review and see if any near dupe groups have showed some privilege, some not. Usually that means they ought to all have been privileged, but then that gives you the opportunity to go in and then review that and catch as a QC function. And we recommend that be done whenever possible in cases. And then this shows how it looks in the document viewer. Same thing, that if you pull up a document, you can see both exact dupes in the document viewer on the right and also the near dupe groups. You can look at those. So when you're doing your privilege review at that point in the document reviewer, you can also jump in and make sure all the exact groups and the near dupe groups are privileged coded as well. Automatic privilege logging is a key feature of modern eDiscovery programs, ours and others. What it does is it pulls the metadata out of particularly emails, but also other documents, and it gets into the system. And this includes the normal elements of a privilege log, including sender, receivers, date, time, document type, etc. And it will pull the subject line of the emails, or at least the last email, the top email in a document, and put that into the privilege log. So you get a first version of a privilege log that has all the information that's needed on that. More fields can be added as custom fields if one wants, but this very much cuts down on the amount of time that is needed to prepare a privilege log. And then when it's all ready, then that can be exported as an Excel sheet as the privilege log. What one does with email chain protocols, we talked about a little bit earlier, is there really aren't a lot of rules on how that's handled. One place where they have done that is in New York, where they've got a specific rule on that, and it talks about what an email chain is, and then if one is there, then it allows of a reduced coding of it, of one entry for the entire chain. There's not any requirement of this in the federals anywhere, and I haven't seen it specifically required in any case law. So if this is being implemented outside of New York, it would generally be done as part of a 502 order. I think there's also local rules in different particular jurisdictions that go into this in more detail and might require something like this as well, but it's not a general agreement as to how this ought to be done. A great area, if it can be done, is categorical designations. And this idea has been around for a long time. And it was actually included in the comments to the Federal Rule Civil Procedure 26 back in '93. It says that document by document law may be appropriate if it would be unduly burdensome with high volume of documents, if they can be included in categories. This is particularly implemented in New York, and it's recommended by the Sedona Conference. In my experience, that has to be agreed to generally by parties, and it will be agreed to only when there's synchronous requirements on privilege production by the parties. If one doesn't have very many privilege documents and the other does, they generally won't agree to it. But it certainly can be agreed to by the parties, and it can be great for reducing the cost of privilege log creation when that can be done. How's this used? Well, the categorical designations are generally a date range, the document type, the sender receivers who's been copied on it, a category description, a privilege justification, and the total documents withheld. When is it used? Sometimes the categories could be communications with outside counsel regarding a matter, communications prepared in anticipation of litigation, work product communications, communications with inside counsel reflecting legal advice in a matter, maybe other categories. This is what it looks like. This is from some documentation in New York where this is recommended, where you can see how this would come out, where instead of having 415 documents entered, it could be handled with a single entry on a document or spreadsheet of 415 if this is agreed to, and this is what the description will look like. Another issue to be watch out for with privilege is redaction issues. In general, of course, sensitive information and possibly privileged information should be redacted prior to production. Issues can come up with that. One is that you'll occasionally see somebody using a tool like Adobe Acrobat and using the wrong portion of the tool. Adobe Acrobat, the newer versions have a redaction tool that does it properly, but people sometimes will go in there and redact using just the drawing tools, but that does not eradicate the underlying text layer. And then there's a lot of famous cases, instances where this has come up, where people will send something out that's redacted and the text layer is there for anybody who searches it or knows how to look for it. So that's not the case in our software with our redaction tool or other modern ones as well with most companies, where the document is converted into an image, a TIFF or other image. We use a JPEG and then converted back into a PDF or TIFF on the redacted version to make sure the underlying text layers are done away with after redaction. Other issues are natives. Usually native files are not being redacted directly. There are some tools on doing that for Excel's. For that as specialty tools, but normally the natives should be withheld as part of the redaction and not been done directly. So if that's been done, then one needs to make sure that the natives are not being accidentally produced as part of a production. our system and others have logic around that to make sure that the natives are withheld. There's a similar issue with container files. If there's been any redaction, then a zip file or other things that are container archive files need to also be withheld, or the privileged information go within that. Again, the log of the eDiscovery program will cover all that as part of a normal production workflow. On all of this, one needs to build in time for QC procedures after the fact on that, and that can be done with running your privilege searches again against your documents ready for production to make sure that your privileged keywords aren't coming up. But one needs to build in time and have that procedure. It's possible to put language around what the privilege log and the privilege procedure is going to be in an eDiscovery order or other case scheduling agreements. We have some sample language in an ESI order that Lexbe recommends for that covers privilege logging, but also a number of other eDiscovery subjects that can come up in general and in Rule 26 meet and confer conferences. And this is available on our website for download or on request from any of our staff. You can see it covering privileged information, the log, and then also having the clawback. We recommend that the clawback be included in really in any case. It's hard to imagine when it wouldn't be a good idea to have a clawback agreement as part of your normal case documentation. Last, I want to finish up with just a summary and some checklists of recommendations. First, make use of Rule 26 and communications with opposing counsel early in document efforts and have any privilege issues and privilege log issues addressed there. Have a claw agreement. Use a modern eDiscovery platform to make sure that you get the benefits of the technology and the logic and protections built in. Make use of categorical logging if it's appropriate for your case and you can get agreement with opposing counsel. Project manage your privilege review and build in time for having protocols and doing your QC review before you make your production. Address redaction issues. Make sure you address you're not producing your natives when you're doing redactions on PDFs or image versions. Consider using a redaction on privileged strings with handling the attachment issues on that. Use an ESI order if possible. It's a good way of handling this stuff early in the case. And use near dupe technology as a safety valve for catching documents that otherwise might have eluded human or other privilege review protocols. Well, that's going to end it for me on this. Thanks again for everybody's attention. Let us know what you think and send me any comments and I'll turn things back over to Jeff. Thank you.
Thanks, Gene. That was a fascinating presentation. Now I'm going to talk a little bit about Lexbe and the Lexbe solution. Lexbe is uniquely positioned to really help boutique law firms and organizations that want to keep eDiscovery in-house solve for those challenges of large and growing data sets. We equip boutique firms with the most efficient infrastructure, expertise, and advanced capabilities to make sure that you protect those privileged documents. So Lexbe really facilitates the mantra of lean and mean for the boutique firm with on-demand cloud-based eDiscovery capabilities. You not only have leading-edge technology and performance and security, but it's a fraction of the cost of dedicated on-site infrastructure of big law. Lexbe auto-scales to ensure we get you from document ingestion to review faster than any other platform. The Lexbe eDiscovery platform can be easily accessed by virtually any internet-capable device, including PCs, Macs, iPhones, iPads, and Android devices, although probably wouldn't recommend doing a large document review on an iPhone. That would be a little challenging on the eyes. Lexbe equips you with state-of-the-art technology that's super simple to use, so you don't have to have a dedicated IT support or litigation support professionals on staff in order to have advanced eDiscovery operations. And only Lexbe equips you with the Uber index. So this is a highly advanced index that is comprised of native characters that are extracted from the documents. All the documents are converted to a normalized PDF, and those are OCR'd. So those OCR'd characters are included in that index, and then also translated characters. So having native and OCR characters is really important when dealing with large document sets, because there are several use cases that really require both in order to assemble a complete data set containing the evidence and privilege documents that you need. In addition to the Uber Index, Lexbe also equips you with advanced technologies that are instrumental in identifying and protecting privileged documents. The Lexbe eDiscovery platform includes email threading and near-dupe groupings, which I find particularly powerful, especially when dialogues cross communication modalities. And it's very, very powerful in making sure that privileged documents don't slip through the cracks. And then technology-assisted review for addressing those very large document sets in a timely fashion. Lexbe's email thread visualization capability has great utility in that you can zoom in or out of large email threads, you can select emails and view the metadata. You can quickly identify where there are missing emails that could have been excluded from a collection or production. Lexbe also equips you with the ability to quickly compare emails side by side and identify the differences via color highlighting and making sure that you're not missing privileged communications. Lexbe also provides the support and professional services in the event that you need them. Therefore, you don't have to have a large litigation support department or IT staff to operate eDiscovery in-house. In many cases, our team acts as an extension of yours and provides staff augmentation in the event that you're dealing with a very large matter or a very large document set and you need assistance. Next, with Lexbe, you don't have to pay an additional per gig rate for advanced analytics. You'll get near duplication, entity identification, sentiment analysis, and image recognition, all included in your Lexbe subscription. Other platforms charge a hefty per gig rate for similar features like this. Lastly, I'll let you know that Lexbe is the most affordable, full-featured DIY eDiscovery platform. We don't charge for processing, we don't charge user fees, we don't charge case fees, we don't charge a setup fee, and you can get started for as little as $5 per gig per month for a 50 gig subscription. Or you can start at $15 per gig per month for our month-to-month flex plan. We recently saved a new client over $700,000 just on a single matter. Think about that when you're looking at your next document-intensive case, and think about the associated costs. Is that creating friction with your clients? Is there a way to eliminate that friction and eliminate the hefty burden that a lot of eDiscovery platforms place on your particular matter? Lexbe eliminates that big financial burden and can save you a significant amount of money. And with that, I'll ask our last polling question, and that is, would you like a demonstration of the Lexbe eDiscovery platform? And while you're answering that, I'll thank you for attending today's session. We'll be making the following available to webinar attendees. You can get a recorded streaming version, an MP3 podcast, as well as a PDF of the slides. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. There will be a survey at the end of the session today, and we take your input very seriously. We greatly appreciate it and value it. We want to continue to bring you very high quality webinars, and your input and feedback to us is really instrumental in that. This webinar is part of the Lexbe eDiscovery webinar series. For notice of future live and on-demand webinars as part of this series, please email us at webinars@lexbe.com or follow us on LinkedIn, and we'll keep you up to date on that. And with that, I'll tell you, watch your inbox for an invite to our next webinar in best practices in eDiscovery. Take care.